Mr. Bubach.
May it please the court, counsel, Ms. Kellen Bubach, represent the applicants and defendants, Sarah Hardy and Family Healthcare of Siouxland. This case arises out of a fall plaintiff experienced in her home. She showed up at the defendant's clinic 1 week later with pain in her arm. She was evaluated, diagnosed with a contusion, prescribed pain medications, and told to follow up in 2 days if she wasn't better. She got ill overnight. She presents to the ER less than 24 hours later with kidney failure, septic shock, and was immediately given IV antibiotics for 48 hours, which were utterly ineffective. She was ultimately diagnosed with necrotizing fasciitis, and ultimately amputating her arm was necessary to save her life. Plaintiff's theory of this case is that the defendants were negligent in failing to diagnose an infection on September 29th, 1 day earlier. Plaintiff's causation argument is that Miss Susie had an easily treatable cellulitis on September 29th when she saw Sarah Hardy, and administration of oral antibiotics would have cured the infection.
I want to back you up a minute.
Sure.
When you first started off, you said, and I quote, she got ill overnight. Does the record show otherwise, that it really wasn't overnight that she got ill?
I think that the record shows that she began to get progressively sicker in the early morning hours of the 30th and came to the ER about noon. The district court correctly granted the defendant's summary judgment motion on causation because no expert testimony supports plaintiff's theory of the case on causation. The only person in this case that has stated that oral antibiotics 1 day earlier could have prevented the outcome in this case is Mr. Humphrey, plaintiff's counsel. The speculative causation theory that's laid out in the briefing, pages 53 to 58, is not supported by any citations to any physicians. Yet plaintiff does not dispute that expert testimony is necessary and does not dispute that speculation is insufficient. But there is no non-speculative expert testimony. There's no expert testimony at all that anyone said, if you gave antibiotics 1 day earlier, she would have saved her arm, this wouldn't have happened, everything would have been fine. No one says that.
You know, there's two theories of recovery here. There's first, it would have saved your arm, and then there's lost chance of survival. Are you saying for both causes of recovery there isn't any expert testimony?
Correct. With the first one, I don't think there's anything that even comes close. As far as loss of chance, no one said there's a chance her arm could have been saved. No one said that. So I don't think there's any.
About the testimony of Dr. Schechter that there's a possibility ranging up to, significant possibility ranging as high as probability that early intervention with antibiotics could have either at least reduced the progression or slowed its progression and potentially have averted as much tissue loss as she experienced.
Sure.
That seems to me that's their key testimony that
sure,
Mr. Humphrey got on cross-examination of the witness, right?
Sure, and I'll address that testimony. First of all, Dr. Schechter repeatedly stated he was speculating as to what effects antibiotics would have. Said it several times, and then Mr. Hilmes on redirect gets him to say specifically, without equivocation, what I'm getting to, we're speculating on the effect of antibiotics had they been given to Sharon Susie on that afternoon. He says yes, nothing else.
But he's speculating to a probability. He didn't say an absolute certainty, and a probability is all you need to get to a jury.
So if we come back to what he actually said then, even if we're saying that that opinion was not speculative, he says early intervention could have potentially averted some tissue loss. That's not, and the way Mr. Humphrey asked the question was a leading question, and Mr. Humphrey's been doing this a long time. He knows the opinion he needs. He asked, can't you say it's more likely than not that this is what would have happened? And he says, I think early intervention could have potentially averted some tissue loss. That's not would have saved her arm.
The way I read the Court of Appeals opinion, Justice McDonald's dissent basically was there were no affidavits or anything that would get you there, and he discounted all these prior statements. But when I read the depositions, first of all, the statement that the testifying expert doesn't comply with Rule 140, Iowa Code Section 147.140, to be a verified statement as to what he's going to say, almost an affidavit.
I don't think that it was a sworn statement.
I don't think it requires a sworn statement under 147.140.
But again, the 1.508 report is not coming into evidence. So it's what is this guy's opinion when he's asked under oath at his deposition, and when he says he's speculating, and when he doesn't give an answer that it's more likely than not the arm could have been saved when he's asked by both counsel, I don't think he gets to escape that testimony because a prior written report that counsel prepared says that.
And more importantly, on pages 334, 384, the appendix 423 to 424, the second expert, because the first one died, adopted all the opinions of the first one and said, those are my opinions. So by adopting it under oath, isn't he making those same representations? I mean, we're at summary judgment stage, and you can cross-examine all you want about speculation and this and that, but it appears to me that, when I read Justice McDonald's dissent, I had some concerns, but it seems to me they're really wrong because all those things were incorporated in the testifier's opinions.
Well, again, I don't think that there's anywhere that Dr. Schechter has said anything that is, I think it's more likely than not her arm could have been saved, even adopting prior testimony from Dr. Crew. Again, particularly when he's asked under oath, we're speculating as the effects, yes, and then when he's also asked, are you here to say her arm was cut off because of Sarah Hardy, and he says no, and then when he also says, I'm not an expert in the treatment of necrotizing fasciitis.
Not an infectious disease person, is that right?
Correct.
He's an ER doctor, is that?
He's a wound care doctor, but we asked, do you hold yourself out as an expert in the treatment of necrotizing fasciitis? And he said no. But I think to bring us back, the entire causation theory for plaintiffs is that she had an easily treatable cellulitis that oral antibiotics would have been effective against. And Dr. Schechter conceded, was asked, hey, in hindsight, when we look at how this progressed, can't we say, and the previous expert said the same thing, he said it affirmatively, I think she had necrotizing fasciitis on the 29th in the presence of Sarah Hardy. And with those concessions, it's undisputed antibiotics aren't effective against that. It's undisputed. She shows up 24 hours later. She's given 48 hours of IV antibiotics, and it doesn't make any difference.
Could I have you talk a little bit about how this case and the Baldy case affect each other? And in particular, we're talking about, I believe it was the report that was given first, and then about a week or 7 or 9 days later was the testimony of the expert. And those two had some differences within them. So can you address that issue as far as how that applies in this case?
Well, I think if the reports that are given, again, the report's not coming into evidence. The reports are, as Justice McDonald points out, they're disclosure of expected testimony. And then if you get under oath and you're asked about those opinions and you refuse even from a leading question from plaintiff's counsel to give the but-for causation opinion that you need in this case, I don't think there's anything for the jury to consider, particularly when you layer the speculation elements on top of it.
So your position is even if he had signed an affidavit saying, I subscribe to this 1.508 report is true and correct and accurate, even if he'd done all that, and maybe he did, in effect, by signing it, that if he says something different at the deposition, it's the deposition that controls.
Correct. I think if you're coming in with the subsequent testimony of, again, the affidavit or the 1.508 report is never coming into evidence. And when he signs that, that's the disclosure of expected testimony. And we've had this happen on occasion where you get in a deposition and it's clear the expert, at least in a large part, doesn't hold the actual opinions or is unwilling to give them under oath at a deposition. That's insufficient. And again, he conceded they had that necrotizing fasciitis was present the day before, and that defeats the entire premise of the case that antibiotics would have been effective to treat a superficial cellulitis. And I think it's telling Mr. Humphrey's resistance to the application for further review doesn't mention the 1.508 opinion at all. And it barely mentions Dr. Schechter's testimony. He tries to rely upon the treating physicians, which again I don't think get there. But my position is the reason for that is because there's not enough there from Dr. Schechter. There's a lot of testimony in the record that earlier is better, but as Justice McDonald points out, the factual issue in this case is not whether earlier medical intervention is better than later medical intervention. It's whether or not she would have suffered the same harm given oral antibiotics 24 hours earlier. And no one has testified that she would have suffered, or that oral antibiotics 24 hours earlier would have prevented this. And that's what the district court said as well. So the problem with the treaters saying if you get antibiotics early enough they work is that none of the treaters said they would have worked in this case, or that September 29th was early enough in this case. And again, that all ties back into not only Dr. Schechter saying she had necrotizing fasciitis on the 29th, Dr. Lamptey, one of the treating physicians, says, yeah, it's by the time she got to the ER the next day, it had obviously been there for a while because there was muscle breakdown causing her kidneys to fail. As to the loss of chance, simply stating something is possible doesn't provide expert testimony to support a loss of chance case. The jury has no way to figure out what the loss of chance is just from an opinion that says, well, it's possible that early intervention with antibiotics would have saved this. I mean, there's a lot of talk in some of these cases about, well, we'll let the jury figure it out. But when the jury gets back there and is asked by the jury instructions to put down the percentage for the loss of chance, there's nothing in this record that provides them any guidance as to what that would be. And again, it wasn't even it's possible would have saved her arm, and it wasn't even antibiotics one day earlier. It was sometime earlier intervention. It was could have potentially avoided some tissue loss, which has never been quantified, nor has any percentage chance ever been given or pled or disclosed in this case. So we would request the court affirm the district court's grant of summary judgment and reverse the Court of Appeals.
Thank you very much. Mr. Humphreys?
May it please the court, thank you for the opportunity to be here. I've had the privilege of representing Sharon and Susie in this case, and I think all of us would agree it's a tragic case. In all due respect, I think that there has been a mischaracterization of the totality of the evidence that was put together on the causation issue. And in saying that, I'm not discounting the opinion of Dr. Schechter. Justice Mansfield, you correctly quoted one portion of his sworn testimony, and I think that clearly gets us to the jury on the loss of a chance theory. But in his Rule 1.508, he clearly said that it would be more likely than not that had she gotten antibiotics the day before, she would not have lost her arm. And I agree with you, Justice Wiggins, that is a sufficient component of this record which should have defeated the motion for summary judgment. This is a jury issue for the jury to
But did he
determine.
abandon that position in his deposition?
I don't think he abandoned it. What he answered in response to Mr. Hilmas's question is, can you say with any certainty how Sharon Susie would have responded to the administration of antibiotics? There isn't an expert in the world that could answer that question without speculation because she did not get the antibiotics. So to say how she specifically would have reacted was impossible. But he was prepared to offer opinions statistically that there are over 10 million cases of group A strep cellulitis in this country, cellulitis and infections, throat infections. They are routinely treated with antibiotics successfully. I mean, the most common kind is strep throat. All of us have taken kids in who have strep throat or earaches, get amoxicillin, and it clears up rapidly. That is usually a group A strep bacteria. There is a small percentage, less than 0.1% of these cases that progress to deep tissue infections. And there is simply no question in this record that this started on the skin when she fell and sustained an abrasion on her skin in her living room. There's just no question. And in answer to your question, Justice Christensen, that this did progress over time. It did progress over time, but Kellen's argument fails in this regard. He wants to argue that there's nothing in this record. There is overwhelming evidence in this record that on the 29th, the only indication was that it was still a cellulitis. Dr. Schechter did not testify that it had progressed to necrotizing fasciitis on the 29th. They want their cake and they want to eat it too. They want to say there was nothing there that should have justified a diagnosis of infection on the 29th out of one side of their mouth, but on the other side they want to say it had progressed so far that it was not treatable. She had a low-grade fever on the 29th. There was no indication that it had progressed to the deep tissue. There's every indication that it was a cellulitis, and the testimony of Dr. Schechter, the testimony of Dr. Vermeury, the testimony of Dr. Rizek, and the testimony of Dr. Lamptey. Dr. Lamptey was an infectious disease expert that cared for her. Dr. Vermeury was an infectious disease expert that they retained the defendants. Dr. Rizek was a general surgeon who did the amputation. All four of those experts testified, if you get this at the cellulitis stage and you administer appropriate antibiotics, it is a very successful form of treatment and you can expect complete recovery.
Okay, so who said that she had cellulitis on the 29th?
Dr. Schechter said it. Dr. Vermeury said that it's not uncommon for cellulitises to progress to the deep tissue and it can happen quickly. Exhibit 1 is the record of that visit to the urgent care clinic, and you can look through there and there simply is no documentation of anything consistent with a deep tissue infection. There is everything consistent with a cellulitis infection. And in this context, every reasonable inference is to be given to Sharon Susie, not the defendants.
Well, we need to look at the record, though. You said cellulitis on the day, or if that's what you called it, on the day of the ER, and had she gotten an antibiotic on that day, show me in the record, especially, and I'm mostly interested in deposition, that those two things equals no amputation.
Well, Justice Christensen, there is nothing in the record that conclusively says that. My position is that's for the jury to determine.
You got to give us something, though. You have to, at that stage of the motion for summary judgment. That's why I wanted to talk to Baldy a little bit, if you could talk about that. But I have two concerns. One is that the patient arrived at the doctor's office or the clinic more or less a ticking time bomb. From the sounds from my review of the record, it looks like she was at a stage. Everyone admits something had been going on for a week. And so within that 7th or 8th day, she goes to the doctor. So that's problematic for me. I'm not finding anywhere in the record where antibiotic on that day would have more likely than not resulted in no amputation. Number two, I'm real concerned about the report and the depot differing from each other, and that's what I consider to be a Baldy concern. Could you address that?
Yes, I'll address both of those. And I've attempted to do that a little bit and maybe make it a little bit more clear. You have to start with Exhibit 1, which is the record of the urgent care visit on the 29th. Then you have to go to Sarah Hardy's testimony, who is the healthcare professional that saw her there and never diagnosed an infection and never prescribed an antibiotic. Then you go to Schechter's testimony, and this is all laid out in my brief, and Schechter says there is no indication that it had progressed to the deep tissue as of the time she was at the urgent care clinic. He talked about the SIRS criteria, which is the criteria used to evaluate the severity of an infection. He said she was not a SIRS patient. She had not progressed to that category. Sarah Hardy says she hadn't progressed to that category. So the evidence is overwhelming. At the urgent care clinic, she had not progressed to a deep tissue infection. She was at a cellulitis level. There is likewise testimony from Murray and from Lamptey and from Schechter that these conditions are progressive in nature, and sometimes they can take a turn for the worse rather quickly and dramatically. And so overnight, that turn for the worse took place. And by the time she gets to the ER 24 hours later, she's in septic shock, no question about it. Her life is in danger. Her kidneys are failing. She took a dramatic change for the worse. The day before, she was still treatable. And then you have to go to the testimony of Lamptey, the testimony of Murray, the testimony of Schechter, that if you treat a cellulitis at that stage, antibiotics are exceptionally sensitive and successful in treating it. In fact, when Sharon got to the hospital, they cultured this bug and found 11 different antibiotics that were sensitive to treating it. And so the question goes...
Didn't Dr. Schechter say that it would take 36 hours for antibiotics to be effective?
No, he did not say. He said that if you get it at a cellulitis level, the treatment of antibiotics is successful by reason of its administration through the blood system to the infected area.
Looking at Appendix 427, where there, it looks like Mr. Hilmas is giving him Dr. Cruz's testimony. At page 48, he says it would take 36 hours for the antibiotics to be effective in this case. You saw that. And answer, I'll defer to his question. You agree, correct? Answer, yeah.
The context of that, Justice Mansfield, is that as this infection progresses to the deep tissue layers, the blood supply to those layers gets obliterated by the infection. And so therefore, you cannot deliver the antibiotics to the most severely infected levels of tissue. And that's why the effectiveness of the antibiotics goes down dramatically once it progresses to the deep tissue. But when it is in the cellulitis stage, I think Murray, Lamptey, and Schechter all say it's very much treatable, and a single dose can have a major impact on the progression of that cellulitis.
I think you're more persuasive about that than perhaps the evidence. I'm trying to find the exact words that you used the term exceptionally successful. Those are very strong words, but when I look at the record and when I read the opinion from the Court of Appeals as well as the evidence, I'm having a hard time finding the language to be as persuasive as you are arguing today.
If you look at page 232 of the appendix, which is Dr. Lamptey's sworn testimony, which would have been offered to the jury, we took those for preservation purposes. He says if you begin antibiotics for what appears to be a cellulitis, you would expect a complete recovery for that patient. Dr. Vermurray agrees with that, and I'll give you the page.
I'm mainly interested in the expert who also gave a written statement that appears to differ from his depo.
And I respect that, but my position is that is but one witness in this case, and the causation case, as this court has recognized in the Oak Leaf, can't remember the full name of the case, you can put the causation case together through multiple witnesses, both lay and expert. Dr. Vermurray, if you look at page 246, he also agrees that complete recoveries routinely occur for soft tissue cellulitis where antibiotics are timely administered. And Dr. Schechter also comments on that in his testimony. I can probably find it if the court...
How about instead you jump to the Baldy comment that I've been wanting to talk more about, which is, let's focus just on your expert. So according to the Baldy case, a party opposing summary judgment may not manufacture a material fact issue simply by filing an affidavit that directly contradicts prior testimony. Now, maybe they're in different order. Maybe we have the report first and then testimony, but I'd like for you to address that concern that I have.
I don't think Dr. Schechter was ever allowed to explain in his deposition the basis of his Rule 1.508 summary, and that would have been a statistical causation analysis. I don't think his testimony was inconsistent with his deposition and would not have been inconsistent with his deposition had the jury been allowed to hear his entire testimony. And he would have based it on the CDC statistics as to the fact that there's 10 million cellulitis infections in this country annually, and out of those, only 9 to 11,500 progress to deep tissue. Why? Because they're treated promptly with antibiotics. And he would have made a statistical argument. His answer to Mr. Hilmas's question specifically was, can you say how Sharon Susie specifically, would have responded to those antibiotics? He cannot, but he could go on to say, statistically, we know that the vast majority of these patients respond extremely well.
Where in the record is the statistical stuff?
It's in Vermurray's deposition. I asked him if he agreed with those statistics from the CDC publication, and he said yes.
On that deposition of the expert, you're saying that he wasn't allowed to explain, but I believe you jumped in and started cross-examining your own expert. And didn't you ask questions once you saw maybe the wheels were kind of coming off the bus during the depot? Then didn't you jump in and ask some questions too?
I asked some follow-up questions to Mr. Hilmas's questions, yes. But I didn't feel a need to do a complete deposition of this witness. He was going to testify live at trial, and at trial we would have provided the statistical basis for his causation opinion. So if I can step back, I see that I'm at the sum up stage. Even though I think Dr. Schechter's opinions gets us to the jury, I don't think there's any question it gets us to the jury on the loss of a chance claim. But I also think it got us to the jury on the underlying causation claim. But if you add to Dr. Schechter's opinions in his deposition and in his Rule 1.508, I think there's overwhelming evidence that a jury could infer that when she presented to the urgent care clinic, she had a cellulitis. It had not progressed to the deep tissue, that the cellulitis infections are extremely sensitive to antibiotics. Had antibiotics been commenced, that she may well have had her arm preserved, more likely than not. The Court of Appeals analyzed all that. Judge Bauer and Judge Potterfield joined together in a decision that overturned the grant of the summary judgment at the lower court level. And I would respectfully ask this court to affirm the decision of the Iowa Court of Appeals and allow Sharon Susie to finally have her day in court. I appreciate your time together, all of you, and thank you.
Thank you, Mr. Humphrey. Mr. Bubach, do you have any rebuttal?
Thank you, Mr. Chief Justice. Just briefly, I want to start with, again, we heard almost the entire argument was this was a cellulitis that was treatable. And we still didn't hear in the record where anyone said this was a cellulitis. And Mr. Humphrey represented that Dr. Schechter said that. But Dr. Schechter was asked about Dr. Cruz's opinion, and Dr. Cruz's opinion on page 54 of the appendix is very specific. I think it's page 54. Is very specific, where it says, looking back with hindsight, she definitely had necrotizing fasciitis in the presence of Sarah Hardy the day earlier. And then when Dr. Schechter was asked, Dr. Crew was able to say with a little bit of look back, because of what he knows what happens when she crossed the threshold less than 24 hours later at Mercy Hospital, that there was a brewing necrotizing fasciitis then and there in the presence of Sarah Hardy. You understand that's what he was telling us. Answer, right. And you embrace that, knowing what we know now, looking back, correct? Yes. That's on, I don't know the appendix page, that's on page 71 of Dr. Schechter's deposition. Additionally, Dr. Lamptey said, yeah, if you're lucky enough to catch it when it's a cellulitis, a lot of times you can treat this. But he also says on pages 68 and 69 of his deposition that you can have a small area of redness superficially and the entire limb is necrotic underneath. And then Dr. Rizek said in his deposition that once it's necrotizing, antibiotics don't work. Vermeury said pain out of proportion to the presentation is a sign of necrotizing fasciitis present then and there in the site of in the presence of Sarah Hardy. And Dr. Lamptey said, hey, this was releasing toxins and breaking down the muscles and clogging up the kidneys well before she got to the emergency room.
Is this case an opportunity to hold that the Baldy rule works both ways, even if the written document is first, the oral testimony then is controlling, and you can't use the affidavit or the written report to manufacture a fact question where the deposition or the sworn testimony, oral testimony, gives it up?
Sure, I think that's correct because that's the purpose of discovery. We get disclosures of what their testimony is going to be. We take the deposition to figure out, hey, what are you going to say? What's the basis for your opinions? And when they say, well, I'm speculating as the effect of antibiotics, and I guess it's possible that some time earlier intervention could have potentially averted some tissue loss. That's not what the report says. And Mr. Humphrey, my position is asked that question because he knew the concessions that the expert gave to Mr. Hilmnes was going to get summary judgment granted against him, and he tried to get that on a leading question to his expert and didn't. And so, let's see if he did also say 36 hours it takes to work, but they don't work if it's necrotizing, and by the time they could have started to work, and especially with oral antibiotics, and no one's saying anything else should have been done differently, the time to digest that and get that going.
You're talking about page 72 of Dr. Schechter's deposition where he agrees there was a brewing necrotizing fasciitis.
Correct.
When she presented at the clinic.
Correct. And that was in response to Dr. Crew affirmatively saying, yeah, when you look back, she definitely had it. And I think the very end of Justice McDonald's opinion is there's no non-speculative opinion or other evidence in the record from which a jury could infer that had the defendants done something different, the harm could have been avoided. And I think that's the problem in this case and why summary judgment was properly granted. Thank you.
Thank you, Mr. Bubach. At this time, the case of Susie versus Family Health Care of Siouxland is considered submitted. You may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.